Welcome to Civil Justice for SA Survivors.
Welcome back to Civil Justice for SA Survivors with attorney Marc Pearlman and Melissa Anderson. Marc and Melissa represent survivors of SA or sexual assault and exploitation across Illinois, guiding them through the civil justice process with compassion and clarity. I'm Lisa Mosby, your host, and today we're talking about what makes a civil sexual abuse case viable in Illinois. Welcome, Marc. Welcome, Melissa. Thanks for being back with me again.
Good afternoon, Lisa.
When someone is first considering a civil case, what does viability actually mean in legal terms?
We don't really evaluate it in legal terms per se. How we look at it is it's very simple, actually. Do we believe we can help this person and improve their life, happiness, healing by hearing them and representing them? So oftentimes for survivors of SA, the biggest issue in their life is that nobody's heard them. And we see that going on right now in this, what's going on with Epstein and all of that. The survivors want to be heard. And viability from a legal perspective is really certainly important, but secondary in our evaluation of whether we think we can help someone.
And for our initial evaluation, what's important with that is understanding what exactly is the individual looking to get out of the process. So that's different for everyone. So whether or not we can help them really depends on what exactly they're looking to accomplish. And our role is often explaining to them the different paths we can take to try to accomplish what it is that they're looking to do. And that varies greatly. And it's often doesn't involve filing a lawsuit.
And Melissa, you mentioned what they're looking to get out of it, but what are the key factors that you look at when evaluating whether a civil SA case can move forward in Illinois?
Well, it's tricky. It's varies, and really it's looking at a bunch of different factors to see. Often, as we've talked about before, statute of limitations is often something we look at, but not entirely dispositive. There's things from a legal standpoint that tolls the statute of limitations, so we look to see if there has been any tolling of the statute of limitations. And also we look to see what the strength of our defenses would be in response to a statute of limitations argument brought by the other side. That's one of the main things that we look at. And we also do some investigation into the perpetrator of the abuse to see what we can find out about what the particular institution knew or should have known about the abuser.
And when we say, Lisa, when we say toll, that's a legal term, and it just means that the statute, under various circumstances, the statute could stop running for a period of time or not be running at all. So there are things legally that can extend the statute of limitations, and there are other things that could actually eliminate a statute of limitations. So it's a complex analysis, and unfortunately, way too many lawyers, when somebody calls them in an SA case, they find out the date that it occurred, and their immediate reaction is that too much time has passed, we can't help you. That's not necessarily accurate.
And how does the involvement of an institution like a school or a church or other organization affect whether a case is viable?
It is much different when there's an institution involved. And I would say the bulk of what we do is when there is an institution involved in terms of employing or being responsible for supervising the perpetrator of the abuse. So our focus is a lot less on whether or not proof of the abuse happening, and looking closer at what the institution was doing in terms of supervising the individual, or in most cases not supervising the individual, particularly in circumstances where they knew they should have been doing that. Often surprised at how much access adults have to children in lots of institutions, particularly schools. There's a lot of rules about being one today. There's a lot of rules about being one-on-one with children that quite simply aren't enforced. And that's something we look at.
And the other thing is, it's interesting when I tell people the work that we do. Their immediate reaction is, "Oh, that's great. These perpetrators belong, in prison forever, and et cetera, et cetera, et cetera." And the involvement of the institutions is really, for us, often as bad, if not worse, than the perpetrator, because these are people that supposedly aren't sick and pedophiles, and yet they have a lot of information about things that occurred, and to protect their own institution, viability, economics, they just cover things up.
And in civil essay cases, how much does documentation or evidence matter from the onset? And what form does that usually take?
Oftentimes, because the abuse happened decades ago, there's often very little evidence in terms of proving that the abuse took place. So often you're looking to see, has this perpetrator been accused before of molesting children? Is there evidence that they have abused children before? And especially with these cases, when you're looking at an institution and trying to determine what they did or didn't do, a lot of that evidence is not available from the outset of a case. Fortunately, we do have over the years been able to gather information about what some institutions knew about particular perpetrators, or generally what a particular institution didn't do, generally speaking, in terms of following their own rules or putting in place safeguards for children. So we do have access to some of that for certain institutions, schools, religious entities, things like that. But oftentimes it's hard because a lot of the information that you're looking to obtain is not readily available. It's in the hands of the people who are safeguarding it and trying to protect themselves. So a lot of times you don't have as clear of an idea of how the case is going to play out in that regard until you engage in some what's called discovery in a civil matter, where you exchange documents and information and have the opportunity to interview or depose people.
And another important thing, Lisa, is that it is very, very unusual that a perpetrator has one victim. Typically, they have numerous victims. Now, there's always got to be the first person to come forward, and typically it's easier to come forward if there's been 50 other victims than to be the first person to come forward. So because perpetrators typically have many victims, we can learn an MO and how they the course of conduct that they engage in order to access their victims of SA and things of that nature. So that's usually pretty powerful evidence of the fact that this occurred. If the victim or the survivor that comes forward to us is expressing an MO that's consistent with what we know.
And then, separate from the statute of limitations, which we've talked about a couple of times, how does delayed reporting or gaps in time affect the viability of moving forward with a case?
Because of the nature of what are crimes, we're handling it in the civil, bringing a civil claim, but really, a lot of times the evidence available right when SA has occurred is not much different than what's available 30, 40, 50 years later. There's usually not witnesses to these events of SA. So it's oftentimes our client's word and story about what happened to them, which can be very powerful evidence. That's still, them telling their story and their account of what happened can be very powerful. And for the most part, people don't make up having been sexually assaulted and sexually abused. It's not something that, even studies have been done on that. It's not something people often make up and come forward.
Yeah. So of course, people ask all the time, well, how many are false allegations and it's a money grab? And our response is always a fewfold. One is, why would anybody make something like that up? And equally, if not more importantly, why would you make something up that happened, you know, decades ago that may be barred by the statute of limitations? You're far better off if you're the type of person that would make up something like that. Why don't you're better off going to the local Target and pretending you slip and fell and sustain an injury. But making up sexual abuse from a long time ago is hardly, it's just not something that people would typically do.
And you mentioned that oftentimes there isn't physical evidence, um, and there's oftentimes multiple instances of this. So, what role does corroboration play in a civil case?
Corroboration could be significant. Again, when you have more than one survivor, there tends to be a lot of corroborating evidence, and or the modus operandi that these perpetrators use is often they find what works and they stick to it. So that's typically very, very helpful if you go, yeah, this is consistent with what we've heard from the other 5, 6, 10, 100 survivors of this perpetrator.
And also, as you get further along in a civil claim, a lot of the corroboration has to do with what has happened in this person's life since the abuse. There's medical evidence in terms of what there's a lot of the same themes in terms of the way survivors of SA have been impacted. So you see that, and a lot of times it takes an expert to opine about their thoughts in terms of the trajectory of someone's life and what that's an indicator of in terms of pointing towards having been SA having occurred when this person was a child. So that's oftentimes where we get corroboration for the fact that SA did occur. That doesn't directly point to who the perpetrator was, but at least in establishing that SA did take place.
You mentioned the person's age. How does the survivor's age at the time of abuse affect or factor into the analysis of the civil claim today?
Legally, their age is important because with respect to the statute of limitations, it does not start to run ever before you turn 18 years old. So when you're a minor, the statute of limitation is not running. Once you turn 18, then depending on the state, you have a certain amount of time then to bring your claim. Initially in Illinois, that was 2 years, so you had until you were 20. Over time, it changed from until you were 20 until you were 28, and then until you were 48, and then now forever. So it's changed over time, but the age at the time of the abuse or the SA is it's really most relevant not to the legal issues, but rather to the damage issues, like how has this impacted your life? And you typically see, again, from medical experts that early on, if somebody's gone through an extreme trauma like SA, it really starts to show up in their life really immediately, even though nobody knows why the survivor is going through this and or what the cause of it was.
And then I imagine that there are situations where a case may be emotionally compelling but legally difficult to pursue. How do you navigate that conversation with your clients?
Well, I think we're candid with our clients up front that there are legal hurdles in order to move forward. But again, our goal in doing this work is not to file lawsuits and get big verdicts. That's not our goal. Our goal is to give a voice to the people that have been harmed so terribly by the SA, number one. And you cannot imagine how many people say, you are the first person that heard me, that listened to me, that heard my story. And when we say whether we can help you, again, that doesn't necessarily mean can we get you money. It means, are you in a better place at the end of this process than you are at the beginning of the process? And there are times, I'm not suggesting we can help everybody, because there are times where we really don't want it. We don't want to harm somebody more than they've already been harmed by putting them through a process that leads nowhere. But if we believe that we can do some good for the person, then we absolutely will take that case. And the other thing is, in addition to helping the person, one of our missions is to make SA less likely to occur today and into the future. And the only way that happens is by talking about it. And when people come forward and they say this happened. So SA today is less likely to occur than it was 20 years ago. You know, the goal is that we can eliminate it. Now that's not going to happen. But we could certainly make it less likely to happen. And, you know, that's when we say that if we can help someone, it includes both helping them in their mental and physical healing, as well as protecting children, because most of our clients that come forward, one of their top goals after being heard is that this doesn't happen to another kid.
And we truly do believe that every person that comes forward is pushing the needle to this being less likely to occur for other children. And we really try to make our clients understand that just simply by coming forward and telling their story and allowing us to tell the institution this is what happened, it's simply that we believe are making things safer for children. And you know, you said, are there situations where a case can be emotionally compelling but legally difficult? I can't think of a case that we've ever had that wasn't emotionally compelling with legal challenges given this area. And really in those cases that, you know, even though they are emotionally compelling and legally difficult, it goes back to really understanding what your client's looking to accomplish.
And, you know, and most of our clients, well, not most of our clients, all of our clients at different degrees feel powerless and out of control. They feel like they've never had that because this happened to them as a child. It was somebody typically that was held in very high esteem, not only by the victim, but by the public at large. And just by coming forward, it changes the power dynamic tremendously, because now you can put a name to the perpetrator of this and the institution that allowed it to happen. And that is really a reclamation of your power.
I think that's where we'll leave it today. Thank you so much for your insights on how folks can move forward with this. Folks, thank you so much for listening today to Civil Justice for SA Survivors. If you'd like to learn more about civil options for survivors in Illinois, you can reach out to pearlmananderson.com for additional resources and to get in touch with Marc and Melissa. Thank you so much for listening, and we will see you next time. If this discussion helped you better understand your rights, please consider sharing it so more survivors and families can find clear, trustworthy information. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.